Hello everyone and welcome to the February 2025 episode of MAIPF Monthly. As always, my name is Amber Rouse Holloway and I'm an executive partner here at our Troy office. Our February 2025 topics include, of course, a case law update. This is a very recent to be published opinion that I believe came down in February of 2025. Then moving on to trending topics in PIP litigation, we'll discuss the employee versus independent contractor issues and its relevance with regard to the No Fault Act, and specifically the case law and how to argue an MSD and how to prepare for an MSD with this type of fact pattern where you have an employee versus an independent contractor and you're trying to either disprove or prove that someone is an employee. All right, moving on to our case law update. This case did recently come down on January 27, 2025 from the Court of Appeals, and again, it will be published, but it pretty much stands for that a denial of PIP benefits based on fraudulent misrepresentations and the procurement of policies and decisions to rescind those policies does not necessarily protect insurers from liability for attorney's fees and penalty interest under the No Fault Act. As we all know, the No Fault Act incentivizes the prompt resolution of claims. Now, this incentive typically imposes attorney's fees and penalty interest against insurers who unreasonably deny or delay the payment of claims. I did put some case law in here for that. Now, Michigan appellate courts have generally carved out three situations in which an insurer's refusal to pay PIP benefits may not be unreasonable. And that's one, where the denial is a product of a legitimate question of statutory construction, two, constitutional law, or three, a bona fide factual uncertainty. Now, disputes over attorney's fees and penalty interest under sections 3145 and 3148 generally put the flexibility of these scenarios, those three scenarios, to the test. Now, in this recent published decision from the Court of Appeals, it extended this rigid approach when it held that an insurer's denial of first-party PIP claim benefits based upon the suspected fraud and the procurement of a policy did not justify the denial of the innocent third party's claim, and found that the insurer was liable for attorney's fees and interest. So basically, we had a situation here where the innocent third party claim was suspended for whatever reason, but we'll go into that shortly, but via suspected fraud, and it had nothing to do with the innocent third party. So the insurer here denied the claim for benefits, stating that the insurer, there was suspected fraud in the procurement of the policy from the insured, rather. Now again, this case, which the Court of Appeals panel pretty much likened to a priority dispute, seems to show that Michigan appellate courts favor prompt payment of claims, especially to innocent third parties, rather than denying the claim and rescinding the policy without an action in equity to rescind the policy. Now, the facts here involved a combined claim for first party benefits by a motorcyclist. His name is Mr. Colin Jr., who was injured when he was struck by a motor vehicle accident, and his medical provider, VHS/Detroit Medical Center. Now here, the motor vehicle that struck plaintiff, or claimant rather, was insured by Mr. Lucas through a Falls Lake Insurance Company policy, but at the time of the accident, the vehicle was being driven by Miss Benson without permission from the owner. Following the accident, Falls Lake denied plaintiff's claim for benefits under Miss Lucas's policy and rescinded Miss Lucas's policy based on some misrepresentations in her application, specifically as to the garaging of the vehicle. Now, since the plaintiff here, Mr. Colin, was an innocent third party, the trial court balanced the equities prior to deciding to extend Falls Lake's rescission of the policy to the claimant. Now, ultimately, the trial court determined that the equities did not favor rescission of the policy and therefore found Falls Lake to be highest in priority and liable for first-party PIP benefits to plaintiff, here, VHS of Michigan. Now, within 30 days of the trial court's decision, Falls Lake tendered its policy limits, which was $250,000, to plaintiff and VHS, but a dispute over apportionment arose between the respective plaintiffs. Now here, Falls Lake then moved for summary disposition, claiming that it had satisfied its obligations under the No-Fault Act by paying its policy limits within 30 days of the trial court's decision, denying its prior motion for summary disposition as to rescission and priority. Now, plaintiffs opposed the motion and moved for attorney's fees and penalty interest. The trial court agreed that with Falls Lake that the denial of plaintiff's claim for PIP benefits was not unreasonable because, according to Falls Lake, there existed a good faith dispute as to the issue of rescission. Now here on appeal, the Court of Appeals reversed and remanded the case back to the trial court, ultimately finding that Falls Lake's denial was unreasonable and that a dispute over whether Falls Lake could rescind Ms. Lucas's policy did not present a question of statutory construction, 1, constitutional law, 2, or a bona fide factual uncertainty, 3, where the insurer's denial may be reasonable. Now here, the panel relied on the unpublished decision in the Graham v. Jackson case, where the court similarly addressed an insurer's denial of an innocent third party's claim for benefits based on alleged fraud in the procurement of the policy, and found that because the insurer was not entitled to rescind the policy, it was not entitled to withhold payment of benefits without incurring penalties under the No-Fault Act. Now here, the panel unanimously agreed that Falls Lake rescission did not present an issue of statutory construction, constitutional law, or a question of fact regarding the accident. Now, the court went on to say that, simply speaking, there was no question that Cologne, an innocent third party, was entitled to PIP benefits from an insurer, the only question of which insurer would be ultimately responsible. Now, as we all know, and we talked about at the beginning of this case, legislature strongly incentivizes us insurers to pay first and then seek reimbursement later when it is clear that a claimant will be entitled to PIP benefits from someone, and it penalizes unreasonable payment delays, which is the case with this situation. Now, moving on to trending topics in PIP litigation. Again, I wanted to discuss employee versus independent contractor scenarios and its effect on the No-Fault Act. Now, questions of priority between potential insurers is ultimately governed by MCL 500-3114, which provides that as a general rule, PIP benefits described in Section 3101, Section 1 applies to accidental bodily injury of the person named in the policy, that person's spouse, and a relative domiciled in the same household if the injury arises from a motor vehicle accident. So simply put, a person must generally look to his or her own personal insurance policy unless there's an exclusion or an exception. Under MCL 500-3114, Section 3, the priority question of whether a worker is an employee or an independent contractor is crucial. And we have this situation come up in a lot of trucking cases, where you have trucking cases or any type of transportation service case. And what I mean by that is you'll have a situation in which a trucker is renting the bed of a truck, but they own their cab. And in those situations, you sometimes have the trucker or the driver as an independent contractor of the trucking company. And they have their own business, their own LLC, but they're doing jobs for this trucking company. Or with regard to any type of transportation service, you have a situation in which for example, medical transportation company, instead of getting employees, they get independent contractors for whatever reason. But you see that in a lot of those scenarios, or in just any scenario in which you have typically a small business or small company that has independent contractors, whether it's a cleaning company or a a company in which someone's doing, I see it sometimes also with not residential cleaning companies, but more so commercial cleaning companies, in which the actual cleaners that you see in these types of buildings, these type of commercial buildings, are actually independent contractors and not employees. Now, Section 3114, Section 3 provides that an employee, his or her spouse or relative, either domiciled in the same household, who suffers accidental bodily injury while an occupant of a motor vehicle owned or registered by the employer shall receive PIP benefits to which the employee is entitled from the insurer of the furnished vehicle. Now, to break that down, you have to prove that this person is an employee and is driving or an occupant of a vehicle that is owned and registered by the employer, and then they can receive PIP benefits from the insurer of the furnished vehicle. So, if you have a situation where a person is an independent contractor and not an employee, they're out. If you have a situation where that person is an occupant of a vehicle that is neither owned or registered by the employer, they're out. And lastly, if you have a situation where that employee is not in their furnished vehicle, they're also out. So that's why it's important when you first open up these cases and first get the claimant's or plaintiff's deposition that you specifically go into vigorous detail with regard to their employment status, meaning their job duties, meaning what type of vehicle they were driving, were they driving their own vehicle, did the employer give them that vehicle, what are their typical job duties, how do they pay taxes, do they receive a W-2 versus a 1099, but and there's not any one controlling factor, which we'll go on to discuss when we get to the case law portion of this trending topics, but there's not one determining factor, so the goal is to get as many factors in your favor as possible, whether you're trying to prove, most of the time you're trying to prove that this person is an independent contractor because your insured has hired this person as an independent contractor. So you want to get as many facts as possible to support an independent contractor, meaning less control from the insured for whatever reason that you typically identify those issues in the deposition. Now, if the driver is an employee, the no-fault carrier for the trucking company or the driving company, residential driving company, is the first in line to pay PIP benefits. Now, if the driver is an independent contractor, the driver's personal no-fault carrier becomes first in line to pay those PIP benefits. Now, the courts apply what we call the economic reality test to help decide the classification of employee versus independent contractor. And again, you want to get as many factors as possible to support your position, whether that's via deposition, via answers to discovery, via contracts that the claimant or plaintiff has signed indicating that they were an independent contractor, whether they themselves understood that they were an independent contractor as well. Now, the economic reality test is highlighted in the case of Adnalalic v. Harco National Insurance Company, and that's the seminal case on this issue thus far. We also have the case of Parham v. Preferred Risk Mutual Insurance Company that highlights this issue as well. Now, the factors to be considered are control of the worker's duties, payment of wages, right to hire and fire and discipline, performance of the duties as an integral part of the employer's benefit business towards the accomplishment of a common goal. As I said previously, it's important to note that under the test, no weight is given to whether a contract refers to a person or independent contractor or an employee. Instead, the person's legal employment status is based on an analysis of these factors. So you can't just say, oh, this person, I titled this person an independent contractor and therefore he is an independent contractor. The court is going to go into some more factors with regard to the daily work that person is committing. Now, here in this seminal case, the plaintiff had contracted with a transportation company, DIS Transportation, to haul cargo. He was under DIS's Transportation's dispatch at the time he was involved in the accident. He sought coverage for PIP benefits from the insurer of his own personal vehicles. Now, the Court of Appeals was tasked with determining whether that plaintiff was an employee or an independent contractor, and the court looked to whether he could refuse loads offered by DIS Transportation. They also looked to whether he was issued 1099 forms or W-2 forms, or whether he was free to terminate his relationship at any time, and whether DIS had other drivers. Now, in those situations, you'll see a variety of interesting fact patterns. You'll see it where the plaintiff or claimant does do work for other companies. That's a factor that could go in your favor. If they're able to contract their work out to different companies to fit their own schedule, if they pay for maintenance that's out of their own pocket for the vehicle, if they knew that they were going to pay taxes out of their wages, if they created their own schedule and said no thank you to certain jobs, and things of that nature. And the court does say that a contract is not the one determining factor, but the more of these factors you have in your favor, the better. And I've also seen it help where the actual plaintiff or claimant 100% understood that they were an independent contractor and not an employee, and gave me examples of situations where they were an employee. This particular case I'm thinking about, the plaintiff had 2 other jobs in which they were an employee, and actually gave me the differences, and that did help. But conversely, I've had a recent situation where the plaintiff admitted that they were an independent contractor, but all other factors, including their deposition testimony, when I asked them these sort of questions, everything else pointed to the fact that they were indeed an employee despite their independent contractor classification. And although they said they were independent contractor, the court didn't buy it and essentially send down an order against them, arguing that they were an employee even if they thought they were an independent contractor. That is all I have for you guys today. As always, thank you for attending today's episode. If you have any questions and or concerns, please feel free to reach out.